Good night. This is U.S. Immigration Attorney Sharifa Tharp. I am here live to take your U.S. immigration related questions. Go ahead, put your questions in the comments. So I have a good topic to talk to you about tonight, and it is going to be who qualifies to get permanent residence in general. So this is going to be a big topic. So I'm just gonna touch on touch on it, scratch the surface, as they say. I'm not going to delve into great detail. That's where the consultation would come in, and that's because there are so many different ways to qualify for permanent residence that I couldn't possibly spend the half an hour to talk about that. So, but let me remind you that I'm here to answer your immigration questions. Your questions are my priority. So feel free, get comfy, feel free, put those questions in the comments. I will answer in between the topic that I'm talking about. Also, if you'd like to schedule a consultation to determine whether you qualify for permanent residence and work permit in the United States, whether you qualify to fix your status in the United States, go ahead and call. The numbers all over my videos. You can also go to the link in my bio, go to the website, and there are different ways to get in touch. There are scheduling coordinators who are available 9:30 a.m. to, I'm good, Jeremy. It's nice to see you. Thanks so much. Brittany, okay, so you called the office, and I hope everything went well. You should have gotten either an after-hours receptionist or a scheduling coordinator who could take care of you, just depending on what time of the day you called. There are scheduling coordinators who can schedule your consultation from 9:30 a.m. to 11 p.m. And then there are after-hours receptionists who answer and take your information, still take good care of you. And then the scheduling coordinator gets back to you on the next business day. But what I want to hear right now are your questions. I want you to put them in the comments box, and I will answer your immigration related questions. So for me, I am going to be talking about who qualifies for permanent residence. So there are a lot of misconceptions that I want to clear up. And there is information that you don't know about that I also want to tell you about. Yeah, so Brittany, that's a scheduling coordinator. So if you called, you probably called after hours. On the weekend, it's noon to 5 p.m. And that's when the scheduling coordinator is going to get back to you. So the after hours receptionist always answers the phone, but they don't schedule. The scheduling coordinators manage my calendar. And so they will be able to get in touch with you and talk to you about scheduling and confirm your appointment. So I'm looking forward to speaking with you, Brittany, in a consultation, of course. Now, keep in mind that the information I'm going to give you tonight is not personal legal advice. It is general information. Even when I'm answering your questions, it is in very general terms because I don't know your circumstances and I'm not your attorney. So I don't know your full circumstances to be able to give you personal legal advice. But however, I am also here to advise you, to represent you, should you want me to represent you as an attorney. And so that's where you can call and schedule the consult. I require consultations to determine your eligibility before I start to represent you. So, is it possible to get back copies of the application that was filed with the USCIS? So, Jeremy, that is possible through a FOIA request. So, you're going to have to submit the FOIA request, and it is done through a specific form. And you can also do it online as well. So, there are different options. You can go to, you can always call. We do help clients to do FOIA requests. Or you can also go to uscis.gov and submit FOIA requests in the search bar, and you'll get the instructions on how to do that. So who qualifies for permanent residence? I'm going to give you a list. So first I'm going to go through family immigration. Employment is also very vast, the employment-based permanent residence, and it's very vast and very complex just because it really depends on your qualifications, the needs of the employer, whether you qualify to even apply on your own based on your credentials, or whether you will need an employer. However, there is the employment option. Usually to submit an employment-based green card, you will have to have an employer, unless you can show that you warrant, you can get or you qualify for the national interest waiver, which doesn't necessarily require the labor certification, and then the extraordinary ability permanent resident. And in a nutshell, that is for individuals who are at the top of their field. They have excelled in their field to the point that they're renowned internationally or nationally, and so they have something to bring to the table to the United States, and so qualify for extraordinary ability. This can be in athletics, it can be in business, it can be in science, education. So those are some of the fields, and the arts. So those are the fields where you could possibly get the extraordinary ability green card. However, there are so many different ways to get permanent residence, and the process is going to depend on your particular circumstances and whether or not you have an employer. If you don't have an employer, then you're going to have to qualify for a type of employment base where you can petition for yourself, like the extraordinary ability green card. Now with family, there is a set list of family members, so U.S. or resident citizens or residents who can apply for their family members. And so I'm going to go through that list. I always get the question, well, I have an aunt here, I have an uncle here, I have a friend here, I have a cousin here, I have a granddaughter here, I have a sister here. Can they apply for me? Now, the sister can if they're a U.S. citizen, not a resident, but a U.S. citizen. But everybody else cannot apply for you. Those individuals cannot directly apply for you. Now, those who can apply for you, or you would qualify if you are the spouse of a U.S. citizen, the parent of a U.S. citizen who's 21 and up, or the son or daughter of a U.S. citizen who is under 21. You will fall into a priority category, meaning you're going to have the fastest process, all being well, and you don't have any other complications in your case, to get through for permanent residence. There are other categories that qualify, and so I'm going to go through those. If you notice, whether you fall into the category or not is very much dependent on your age in some cases. So you're going to hear me talking about under 21 and over 21, unmarried, married. That very much matters in how long this process is going to take for you, and where you're going to fall in that priority list. So here's a question. What must one expect if USCIS requests initial evidence for Form I-130 petition for a spouse? So if the USCIS requests evidence, it sounds like a request for evidence, but that is usually comes down to evidence to show that it's a bona fide marriage. Now, you must include that evidence with your application. If you don't, it could lead to a denial. It could lead to a delay because you've received a request for evidence. When you receive a request for evidence, right now they're giving you 60 days on top of the 60 days that they already give you to submit it. And then after that, they're taking months to review it to get back on track. So it's very important that you try to avoid a request for evidence. Sometimes it's not, sometimes it's unavoidable. But in cases where you are preparing an application where you can avoid a request for evidence, definitely make sure you do that. The way you can do that, of course, is to make sure that you get the right representation, get the right help. Now, evidence showing bona fide, request for initial evidence, there's required evidence, and that's going to be like your civil documents, identifying documents, proof of that your spouse is a U.S. citizen or resident, and also evidence of the bona fide marriage. Evidence of the bona fide marriage is going to be anything that shows that your marriage is real. Joint property, pictures, affidavits from friends and family, travel, if you are apart right now, so if one is in Jamaica, one is here, show Western Union or money transfer receipt showing that the both of you do trade, transfer money back and forth as spouses. Even if you're in another foreign country and the both of you own property there, that is very significant. So those are examples of evidence of bona fide marriage. Also, travel receipts showing the times that you have met in person. But those are the types of evidence. But Stargirl will remember that I am not your attorney. I'm not providing personal legal advice. So if there's something you're concerned about, definitely schedule a consultation and get the right representation to help you through the process. Hi there, I'm America Brown. It's nice to see you. So keep putting those questions in the comments while I talk to you about who qualifies in general. This is a very general topic tonight because I kind of want to get back to the basics to let you understand how this works to qualify for residence in the United States. Now, qualifying for residence in the United States isn't for everybody, anybody who wants to come here, unfortunately. It is for the select few who qualifies. And you can qualify through an employer, through a family member, or if you have humanitarian means like asylum to apply for. Asylum doesn't directly lead to permanent residence, but first you get asylum and then you can have the ability to apply for permanent residence afterwards. So I'm going to go through these generally so that you understand how this works, because I do get a lot of questions about you're here but you have absolutely no ties, absolutely no kind of experiences in your background that would render you eligible. And I sometimes get questions like, well, what if I'm here working and I've been working for 5 years, even though I don't have any relatives here, can I still get permanent residence because I've been working? And the answer is unfortunately not. There has to be a specific qualifying reason or criteria for you to qualify for permanent residence and a work permit in the United States. So I already touched on employment to talk about their different categories, and it really depends on what the needs of your employer are, what are your qualifications, and whether you even have an employer to begin with. So usually, most commonly, you will need to apply for permanent residence through an employer. There are situations where you are maybe extraordinary, meaning you're at the top of your field in arts, science, business, athletics, education. If you are in these fields and you have shown extraordinary ability, then that could definitely be a way for you to self-petition. Outside of that, you will likely have to have an employer who is willing to apply for your permanent residence. Now, with family, I just mentioned earlier about the immediate relatives of U.S. citizens. Hi there, Alicia. So immediate relatives of U.S. citizens. So will a request for initial evidence prevent the processing for a work permit? So Stargirl, usually not, unless it's actually the request for evidence is coming from the service center that's processing your work permit. So if this is coming from the individuals who are trying to make a decision on your work permit and they need something more, then that's going to delay it. Otherwise, usually not. While your application is pending, the work permit will be pending separately from the adjustment of status. Can you get a work permit on P1 without changing your visa? So Rovain, it depends on what the basis of your P visa is. I've told you this before. Schedule a consultation and let's get into the nitty-gritty, because I don't know what your P visa is based on. The P visa is very specific, and it's giving you the status for the specific reason to come to the United States and carry out that specific task or purpose. And so usually you can't go outside of that, but I would need to know what are your intentions and how did you get your P visa. So schedule a consultation and then let's talk some more about your particular circumstances. So now I spoke about qualifying for permanent residence as the immediate relative of a U.S. citizen. And this is the spouse of a U.S. citizen, parent of a U.S. citizen who's 21 and up. So if your child is under 21 and is a citizen, they're not going to qualify yet. They have to be 21 and up and a citizen to qualify to sponsor you. Or if you're under 21 and unmarried, you will fall into a priority category where you don't have to wait until, you don't have to wait for what's called an immigrant visa number. They will first process your petition, make a decision on it, and send you right through to the interview process. And the priority process right now is taking 18 months to 2 years, and it is quite, while it may seem long to you, it is shorter, much shorter than the other processes. And I'm going to mention the timeline for the other processes. So you are welcome, K Uniquely Blessed. It's my pleasure to take this time out to answer questions. And so my question is, can someone travel while out of status but started the process or already submitted their documents through marriage? So K Uniquely Blessed. If you are outside of the United States and you are currently waiting for your process to be completed, it's when you are coming to the border, you face the risk of being turned around and getting your visa canceled, because based on the documentation that's pending, they're going to know that you have immigrant intent. You have the intention to move to the United States, and that's contrary to the visitor's visa. So in that regard, you have to be careful, and you have to understand that you're bearing the risk of coming and finding yourself in trouble if the officer doesn't like your answers. While I've seen it go both ways, where when you're trying, people have come in with their visa and they've gotten no trouble from it. But then again, you've had some who they have papers pending and they come in with their visitor's visa and they do have issues. So this is my least favorite question, just because it can go both ways. And so what I do tell you is if you're going to travel, you have to understand that you're bearing a certain risk. You have to come in. Of course, you still have to be honest with the officer, because the officer could be asking you a question about what your intentions are, whether you have papers pending, and he's looking right at it. He or she is looking right at their screen and they know exactly the answer already. And so you want to make sure that you are honest and upfront, and that you can show, coming in, you can show that you have every intention to leave. Now, if you are here in the United States and you're out of status, and I think that's what you're saying, then definitely don't travel if you don't have a travel document. When you're applying for adjustment of status, that's staying in the United States and applying for permanent residence, then you get the opportunity in some cases to apply for a travel document. That travel document will allow you to leave for short period of time. I usually say if you don't have to leave, don't leave. I am one to be very cautious. However, you do have situations, emergencies where you have to leave the country, and the travel document would be what would allow you to travel and be able to re-enter the United States. But you're going to always hear this, that when you travel, you have to understand that you are bearing a certain risk again. Because if you're while you're outside of the country and they make a decision and you're on your application and you're coming in and it's not a decision that's favorable, they may just very well deny you entry. So you have to be very careful, even with the travel document. But that's what the travel document is there for. And K, uniquely blessed. As usual, this is not personal legal advice. So if you are concerned about something in particular, it's always best to get legal advice. And then Daniela Shantz, good night. How much is the consultation? It's $150 for up to an hour. And in that time, what I do is I go through your particular circumstances and I determine, first I determine what your needs are and whether you qualify for any kind of relief based on those needs. You will walk out knowing your options, knowing what you qualify for, knowing how to approach your situation. And so I always urge you to go ahead and schedule, and it is definitely worth your time and money. So hey, Kezari, is it possible if I get asylum in the US to get my child that I left in my home country? Yes, so children can also come with you once you are granted asylum. If I travel to the US July and come back in September, can I travel back in December? So Tamara, I can't tell you in specific. I don't know what your situation is. It's really going to depend. That advice is going to depend on how long were you here to begin with? Did you overstay? Are you complying with the terms of your visa? You know, you have the visa, and if it's a multiple entry visa, that visa is there to be able to travel back and forth, but it's not there for you to try to live in the United States. And sometimes if you're traveling very often, so you're coming back and forth, they can start to question you about whether you are coming into the country to work. So you have to be very careful about your frequent travel, and you have to make sure that you can show the purpose of your trip and you can properly explain to the officer each time why you're traveling so often, just in case you get that kind of line of questioning. But the visitor's visa is, as long as you're complying with the terms of your visa, then you can definitely travel back and forth. You just have to be honest and upfront. So Daniel Shantz, you're welcome. Okay, so Daniel Shantz, yes. So in my consultations, I really did delve into detail and see if you qualify for anything. So I know some attorneys have very short consultations to determine whether they can represent you. In my case, I like to delve into a little more detail because sometimes there are options that you may not know about. That detailed consultation allows me to determine whether you qualify for anything. So Tamara, it's a B2 visa. So yep, so visitors. So no, I only travel once a month with my kids. So when you're coming in, just make sure that you can explain to the officer your reasons for traveling. But Tamara, keep in mind that this is not legal advice, and I can't tell you definitely if it's gonna be okay, because I don't know your situation and I'm not your attorney. But when you're traveling on your visa and you've complied with the terms of your visa, just make sure to be honest upfront and make sure you can show the reason that you're traveling. Okay. So Shani Sept 14, how do I apply for the work permit? So let me tell you, you're welcome, Daniel Shantz. So let me tell you, when you apply for the work permit isn't just a freestanding application that you can come in and say, okay, good, I'm ready to apply for the work permit now. I think that would be too good to be true, especially for a U.S. immigration attorney, right? If you could come in, overstay, and then just apply for your work permit. Unfortunately, it doesn't work like that. When you're applying for a work permit, you're usually applying for your work permit along with another type of immigration benefit or relief. For example, if you qualify for adjustment of status is the process of applying for permanent residence while you're in the United States. Then that could allow you to apply for the work permit, so that while the adjustment of status process is pending, the green card process is pending, you can work at the same time. However, if you're outside of the United States, that is not going to apply to you. What you would have to get, if you're outside of the United States, you'd have to get an employment-based visa. Most employment-based visas, they're going to require you to have an employer who is going to hire you or sponsor you. But if you're in the United States and you're applying for an immigration benefit or relief, so if you're applying for adjustment of status, applying for VAWA, VAWA is if you're being mistreated by a U.S. citizen or legal permanent resident spouse, parent, or citizen son or daughter. This could also be a way for you to qualify for a work permit while you wait for the VAWA petition to be pending, or after you're approved, you can get a work permit. Also, T visa, victims of trafficking. So if you're lured to the United States and then you found yourself working, if you found yourself in someone's home working for them with little pay, being mistreated, that is a form of labor trafficking. If you were the victim of a qualifying crime like stalking, domestic violence, and this was reported to the police, then this could be a path for you. And these also allow you to get work permit. Also, asylum, if your asylum application has been pending for more than 365 days, then that could be for you. So let's see. Okay, is it possible to get asylum in the U.S.? I think I answered that one. So, all right. So I have been talking about ways to qualify for permanent residence while you're in the United States or outside of the United States. I'm just talking in general terms. Who qualifies? So I talked about immediate relatives of U.S. citizens who take priority in this process. Right now, priority means 18 months to 24 months. Could be less if you're lucky, freakishly lucky, and it could be more if you're not so lucky. Sometimes there are delays, and that's what I talk about often. Avoid delays by getting legal representation and doing your application correctly, so that you don't have these delays like request for evidence, or it's pushed to the side because it doesn't have enough evidence, or it's rejected because you forgot forms or you forgot some piece of important evidence that was required. Now, in the case, now let us look at the other categories. Now, other categories are, the next category is going to be the son or daughter who is 21 and up, age 21 and up, who is unmarried, of a U.S. citizen. That process is taking 6 to 7 years. And yes, you heard that correctly, it's taking 6 to 7 years. So there's a misconception, understandably, that this is also a faster process if your parent is a U.S. citizen. It's faster if your parent is a U.S. citizen and you're under 21 and unmarried. However, once you get to 21 and up, it is a frustratingly long 6 to 7 years right now. And unless the law changes, of course, and there's something opens up to allow to clear this backlog, it's a 6 to 7 year process. So if you're here without status and you are waiting for your citizen parent to apply for your permanent residence, but you're 21 and up, then you will not qualify to apply in the United States. and you may have to look at applying for a waiver. You'll still have to qualify for the waiver, but the waiver can help to fix your situation and still allow you to go on and get permanent residence. Now, the next category is going to be the relatives of green card holders. So those are going to be the son or daughter under 21 and unmarried of a green card holder, or the spouse of a green card holder. That I have good news. With that category, it used to take long, but now it's current. When I mean current, I mean it is moving as fast as if you were an immediate relative of a U.S. citizen. And that is happening because right now there's no wait list for an immigrant visa number. And so it is a faster process. You are looking at about 18 to 24 months for that process. But I like to emphasize that you need to make sure you apply ASAP for that. But get legal advice first, get legal guidance, especially if you're here without status, to make sure that you are on the right path. Remember, it gets more complex when you're out of status, and you want to make sure that you fix your status in a way that you actually qualify for. But spouses and children under 21 and unmarried of green card holders can now apply and get through at a faster pace. Now, not such good news for children, sons or daughters of green card holders who are 21 and over and who are unmarried. Unfortunately, in their case, it's 5 to 6 years. So it is still a lengthy process. But if you are here and you're out of status and you're and you, of course, you know you can't leave the country, because if you're out of status, you've overstayed. And if you've overstayed over 180 days, that turns into a 3-year bar, meaning once you leave the country, automatic bar, you can't come back. And so you know you're at a point of no return where you're definitely going to have to look at the waiver process. That's what I help my clients with, is this waiver process. First, I determine whether you qualify for it, and then represent my clients to prepare the waiver and get through to the end of the process. Now, the next category are the married son or daughters of U.S. citizens. That is one of the longer processes. Right now it's taking 12 years. The upside of it is that you get to carry your spouse and your children under 21 and unmarried along with you. So that is awesome, except the processing time feels impossible. It's 12 years right now. And then lastly, the siblings of U.S. citizens who are 21 and up, that is a minimum of 14 years. So it's a very long process, but if that's your only way to qualify and you have the time, then definitely this is a way for you to get permanent residence, but it is not a quick and easy way to fix your status if you're out of status in the United States. So what if you have a child at 21 years? How long it takes if they file for you? So about 18 to 24 months. Could be less. I have seen as short as 9 months, but prepare right now, just because of the backlog, longer processing times. Prepare for a 1.5 years for this child sponsoring their parent. And so just remember, for a son or daughter, we still like to call our 21-year-olds children, of course, our children, but for a son or daughter who's 21 and up, they have to be a U.S. citizen, and they have to be at 21. So, and thanks so much for the great vibes. I appreciate it greatly. So that is how to qualify for permanent residence through family members. And so through that list, that detailed list that I gave you, along with the lengthy processing times, I have indicated which family members can apply for you. Unfortunately, that does not include your friend, your cousin, your aunt, your uncle, or anything like that, or grandchildren. or even grandparents in some cases. Now, where I think this misconception has come from is that some children do get to the United States through their grandparents indirectly, or through their aunts and uncles indirectly. That's because if a parent sponsors their son or daughter and they have children under 21 and unmarried, they get to go along with their parent. But that grandparent isn't going to directly sponsor the grandchildren. That is not allowed. Same with aunts and uncles. The aunt or uncle is sponsoring the sibling, and the sibling can bring along their children who are under 21 and unmarried. And so that's how they indirectly get the permanent residence, through an aunt or uncle. So Brittany, I'm married to a citizen and I'm living in America. How long does it take to get a work permit? And do we have to live together? So Brittany, it's taking about 6 to 8 months, and if you don't live together, they're going to scrutinize your marriage with a lot more detail and questioning. And I can tell you from now that they are going to approach your marriage with a lot more skepticism. So it is in your best interest to be living together. Because the way they're looking at it is, if you're both in the United States, why aren't you living together? And they're going to have to get a good reason for that. And in some cases, they have denied permanent residence because they didn't really believe the reason that the spouses were living apart. Now, I know in some cases, spouses, they have jobs that they don't want to leave, and the way they compromise is to live apart, maybe see each other on the weekends. And so if this is the case, you need to make sure that you have your evidence lined up and that you strengthen the rest of your evidence. Now, make sure too, Brittany, that you get legal advice, because this is general information and I don't know the rest of your situation. I don't know how strong the rest of your application is. What did you submit as evidence? If you submitted a weak application from the get-go, then that is going to definitely create issues for you at the interview, going into the interview. And then if you hit the officer, or the officer realizes that you live apart, then definitely that's going to raise some issues. What's the processing time for husband to wife? About 18 to 24 months right now. If you're living in Jamaica and married to a U.S. citizen, how long is the process? Prepare for an 18-month to 24-month. So Brittany, I'm looking forward to speaking with you too, and to assist you through your process, should you qualify. So thanks everyone for your questions. I also delved into detail about ways that you could qualify through family members. That is the most common way. And believe it or not, if you do have an employer, that can be a fast process as well. If you have a qualifying employer who can get you the permanent residence. But family immigration is the most common way to obtain permanent residence. And so I hope this information was helpful to you, and I hope it cleared up some misconceptions. And I just want to quickly go through some other options. So what if your relative, your U.S. citizen or legal permanent resident spouse or parent, if you're under 21 for the parent, or if you're under 25 in some cases, or if your citizen's son or daughter are not willing to apply for you because they're mistreating you, maybe they're using this as a tactic to sabotage you, this could be a way for you to also obtain permanent residence in the United States without the need to leave, and qualify for the work permit and adjustment of status. Also, if you're a T or U visa holder, so you know who you are, but T visas are for those who are victims of trafficking. U visas are visas for victims of qualifying crimes. If you felt like you've been in a situation like this, schedule a consult and let's talk more about your situation and see if we can get you the T or U status. if you qualify and you do get these statuses, you can get a work permit and get permission to live here and work here for the next 4 years. And if you retain that status for 3 years out of the 4 years, you can adjust status to permanent residence. So my friend was telling me about a new bill passed to grant undocumented immigrants residency if they are essential workers. Is that true? So Brittany, I've been keeping a close eye on it. Unfortunately, it was not approved. So that is dead in the water right now, and it has really taken a backseat. So what was happening is that there was an immigration provision in the reconciliation bill. If you've been watching the news, you've seen it all over the news, and Congress is currently wrangling with it right now. They're fighting at each other's throats about it. And a part of that was to try to grant undocumented immigrants, which included essential workers, dreamers, those who came here as minors, TPS holders, and essential workers and farm workers, the ability to adjust status. However, the Senate parliamentarian struck it down, said she would not approve of it, and because of that, it has not gone further. And they're trying to work out other plans. However, they can't even agree on the basics of this bill, and so the immigration bill has definitely taken a backseat. But as soon as I get more information and more news on it, I'm going to keep you updated as I come on here every night at 9:30 p.m. Eastern to answer your questions and to give you information that is important to you. The answer to your question is no. There is no bill that has been passed. It is not law. Nothing has happened. Can I file petition for adjustment of status because my tenure isn't up? So Sexy Tina, I'm glad you brought this up, because if you are here in the United States and you overstayed, your tenure is not valid anymore. Once you violated the terms of your visa, right? You came here, you were given 4 months to stay, you overstayed, you decided you're gonna stay here because things are not better in your home country. In that case, your tenure is not valid anymore. You can't travel on that visa. It's invalid. So I want to make sure you understand that, so that you don't, you don't even think you can travel on it. If you've overstayed, you can't travel on your 10-year visa anymore, right? And so you are still, because once you've overstayed, you're out of status and you would not be able to qualify for adjustment of status. But Sexy Tina, if you do have certain qualifying relatives, so if you have a U.S. citizen or legal permanent resident, spouse or parent, and that spouse or parent will experience extreme hardship if you don't get the green card, that's one way to get forgiveness for the overstay and still be able to go through consular processing. That means a process at the embassy when it's scheduled. But you, at this point, unless something changes in the law, you wouldn't be able to qualify. If you have a child but not married, can you file for yourself? The child is a year old. So Brittany, unfortunately not. Your child has to be 21 and up and a U.S. citizen to be able to apply for you. So thanks everyone for your, Brittany, if you were married to the child's father and you're divorced now, I don't know if that's your situation. That's where the consultation is very important. There may be a way for you to self-petition. If you, and it depends even on the situation with that, the child's father. Were you married? Was it another type of situation? That's why I like to do the consultations, to kind of delve into more detail to see if even the experiences that you've been through can qualify you for a form of relief or status in the U.S. Thanks everyone. Now if you'd like to schedule the consultation, go to the link in my bio. It's going to take you to the website. You can fill out the contact form if you really don't want to go on the phone, or you can call. There's a scheduling coordinator who is going to answer take your information, and then a scheduling coordinator will get back to you and schedule the consultation. So I'm looking forward to speaking with you in a consultation, or if not, I'll see you tomorrow at 9:30 p.m. Eastern. It was a real pleasure to answer your questions, and I hope to see you tomorrow or speak with you in a consultation. Have a good night, everyone.